If a door slams shut on a police officer's trigger finger, crushing it, is that an accident? To find out, you have to read Rizzo versus DiNapoli. It's only 22 pages. Don't have time for that? I got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the case of Rosa Rizzo versus Thomas DiNapoli. This can be found at 2022 New York Slip Opinion 06027. I attached to the description a link to that decision. This was published by the Court of Appeals on October 27th, 2022. This is a civil case, an employment law case. The issue in this case is the definition of the term accident in Retirement and Social Security Law 363. I'll explain all about that in a moment. The law you have to understand and appreciate this case is that Retirement and Social Security Law 363 deals with New York State and local police officers and firefighters, the disability benefits entitled to those individuals. And essentially, if a firefighter or a police officer becomes physically or mentally incapacitated to perform the duty that they're entrusted with, they are disabled. The source of that disability is tremendously important. It's either an accident or the source is a non-accident. But the difference is extremely essential to determining how much compensation of retirement benefits they get. If a police officer or a firefighter becomes disabled due to an accident, they get 3/4 pay, 75%. If it's a non-accident, it's 50%. And the difference is that an accident has been defined as a sudden, fortuitous mishap or mischance, unexpected, out of the ordinary, and injurious on impact. So an accident has to be something that a person didn't expect and not the result of willful negligence, which is, if you think about that, if a police officer is injured wrestling with a suspect or wrestling with the defendant who just robbed a bank and injures his back, that's not an accident. So it's 50% benefits. But if the police officer is at the office typing up a report and falls off his chair, that's 75% benefit because it's an accident. If a firefighter is burned in a building performing the firefighter function, 50% benefit. But if the firefighter trips going down the stairs of the firehouse, 75% benefit. So what are the facts of this case? The facts are that Rosa Rizzo, the plaintiff, is police officer Rosa Rizzo of the Port Authority Police Department. And on a blustery, windy, gusty February night, Officer Rizzo had just finished rendering aid to a civilian, bringing the civilian to an ambulance, and then starts walking back to the MTA police booth to fill out paperwork. And Officer Rizzo knows that the door to this MTA booth is about 80 to 100 pounds and it's heavy, and it can be dangerous. And as she's opening the door, a big gust of wind hits it and slams it shut on her trigger finger, her right index finger, crushing it, rendering her unable to perform police duties, at least temporarily. So she files a claim for disability. She's disabled. She can't perform her duty. And the hearing examiner says that was not an accident. That was not an accident under that term because she had a reasonable expectation that it could happen. And the appellate division agrees. It goes to the Court of Appeals. And they say, the majority decision says that the hearing examiner and the appellate division was correct, that this was not an accident. It was not unexpected because she knew it was a heavy door. In fact, she tried to prevent it from slamming with her finger. That's why it got crushed. So they say that is not an accident. And so she will get 50% benefits. The dissent by Judge Wilson says that's what we would call anywhere else a workplace accident. She didn't intend to hurt her fingers. And why should it matter? So Judge Wilson disagrees with the majority and proposes a two-part test. I want to emphasize this is the dissent. The majority said it was not an accident, but Judge Wilson says it was, and proposes this two-part test. Whether the nature of the hazard is part of the bargain for risk of the job, and whether it's totally unexpected and out of the ordinary, or as part of the ordinary risks of daily life. Under that test, according to Judge Wilson, this would be considered an accident. And so Judge Wilson would have this be a 75% disability benefit as opposed to 50. And that's TLDR. Basically, it's application of the general rule of accident, but it emphasizes that the Court of Appeals thinks that even a door slamming on an officer's finger is not an accident because she knows that the door is heavy and dangerous. And a normal, a risk that the officer is aware of is not unexpected, and therefore it's not an accident when it happens. TLDR, Rosa Rizzo versus Thomas DiNapoli. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.